The Constitution, I'm going to read this in case you people in the back can't read it. The Constitution, this is a definition of originalism from a book, Jonathan Guineap, Against Constitutional Originalism. It's a thesis of it. It breaks it down. The Constitution's meaning is what its text communicated to the public at the time of its enactment. Being written down fixes the meaning of the words that are used. Thus, the Constitution's meaning remains the same until its words are formally changed by an amendment. This meaning, until changed, is therefore the law. Because the Constitution is the fixed meaning of its words, the task of interpretation is to recover those meanings, which is accomplished by focusing on the words themselves, and when necessary, by utilizing conventional methods of legal interpretation, including what those words were commonly meant to mean to the public when it was adopted. It doesn't mean the founders. There's too many of the founders. We don't know who they are. So the idea is that the Constitution means what it says as it was understood at the time. That is the essence of originalism. Now, would you hit the next slide? This is 4 basic concepts.
No.
Go back one. There you go. This is from a book by Lawrence. It's a debate, constitutional original, a debate between one of the primary legal scholars in favor of it, Lawrence Solem, and Robert Bennett, one of the premier legal scholars who opposes it. Solem says there are 4 basic ideas. The first one is the fixation thesis. The linguistic meaning of the text was fixed at the time each provision was framed and adopted. The idea of writing something down fixes that idea at a point in time. Next is the public meaning thesis. Constitutional meaning is fixed by the understanding of the words and phrases, the grammar, the syntax that characterize the linguistic practices of the public, not the intention of the framers. Because there's too many. Who are the framers? There are 45 of them sitting in the room at the time. Eldridge Gerry, who was the governor of Massachusetts, refused to sign the Finnish Constitution because of its slavery provisions. Does that mean he's not one of the framers because he didn't sign it? Jefferson, who's one of the most important thinkers of the time, was in France. He wasn't there. John Adams was in England. He wasn't there. Most of those guys were young. They were not necessarily the people who were there and who approved the Declaration of Independence. They were delegates chosen by their states to attend. They came from a lot of different ideas. That's why it's not the intention of the framers. The third one is the textual constraint thesis. The original meaning of the text of the Constitution has legal force. It's not just a symbol. In other words, they didn't write this down, these words down, because they wanted to give you a sense of what they were thinking about. They have meaning. They become the law. They have legal force. And the last one is the distinction between interpretation and construction. Constitutional practice has 2 distinct activities. The first one is interpretation. It discerns the linguistic meaning of the text. What do the words mean? What did they mean to average people at the time? And the second is construction. What is the legal effect of what that meaning is? That is the essence in these 2 slides of what we're talking about when we talk about originalism. This is, and I've gone through this exercise, so because I can't give a lecture on the pros and cons of originalism without letting you know exactly what it is. And that's what these 2 slides do. The meaning is what the text communicates to the public at the time. That's a critical idea, that writing something down fixes it gives it fixes it. It's there. It has legal meaning. It is the law. That is the essence of originalism. Now, one of its early adherents was law professor and later judge Robert Bork. Some of us probably remember who this idiot is. While he was a professor, sometimes my predilections come out. I've really worked at this lecture to try and take myself out of it as much as possible, but I can't. While he was a professor at Yale Law School, he wrote an article that was published in the Yale Law Review called, quote, "Neutral Principles and Some First Amendment Problems," close quote. He advocated that judges should take from the Constitution specific values that the text or history show that were put in there and intended to which into rules that we should obey. That was his idea. The term originalism was actually coined by a Stanford law professor named Paul Brest in a law review article that he called "The Misconceived Quest for the Original Understanding." He called it originalism, but didn't like it. Precursors of this idea of originalism included Bork, William Rehnquist, Reagan's Attorney General Edwin Meese. Meese was the Attorney General in Alameda County, was a deputy when I was a public defender in Alameda County. I remember him, talking. I didn't try a case against him because he didn't try ordinary felony cases then. He was in charge of deciding who tried cases, but I remember him. The doctrine was advocated as an antidote to the perceived excesses of the Warren Court. This is what brought it about. From the Warren Court, as you know, from Warren's appointment in 54 or 53 until his retirement in 1969, and the liberal majority in the court that persisted thereafter for a number of years. And let me just list by dates a number of cases and just think about this as you're going through. This is the Warren Court. 1954-55, Brown versus Board of Education. School desegregation is mandated under the 14th Amendment's due process and equal protection clauses. 1961, Mapp versus Ohio. The Fourth Amendment's ban against unreasonable search and seizures is binding on the states and local governments under the 14th Amendment. And this is important, due process of law requires that they apply the exclusionary rule, which was a judicially created rule of evidence that doesn't appear in the Constitution, but the court held that this must be the equal protection and due process requires that local courts apply the exclusionary rule, which says that evidence obtained from an illegal search is inadmissible in court as the only remedy for a violation. That this remedy, which was a judicially created rule, is required under the Constitution. 1962's Engel versus Vitale. School prayers are banned as the First Amendment's Establishment Clause prohibits any official religious activity from which it could be surmised or inferred that the school board, a governmental body, favors or supports the activity. That in effect, the court is saying that the Anti-Establishment Clause prevents a government employee's free exercise clause when that employee is acting in an official capacity. It's basically favoring one part of the First Amendment over another part where they come in conflict. This is something that the court's going to deal with again this year. 1964. We're still in the mid-60s. Baker versus Carr and Reynolds versus Sims. The Equal Protection Clause in the 14th Amendment mandates that congressional and state legislative districts be of equal population. 1963, Gideon versus Wainwright. The 14th Amendment's Due Process Clause incorporates the 6th Amendment's right to counsel, so that all indigent defendants who are charged with a jailable offense are entitled to counsel at the state expense. 1964, New York Times versus Sullivan. Public figures are largely immune from state defamation laws under the First and the 14th Amendment. Griswold versus Connecticut. Connecticut's anti-contraception laws interfere with the married couple's right of privacy. Although privacy is not mentioned in the Constitution, it's implied by, quote, a penumbra emanating from other rights expressly protected in the Constitution. How is something, a penumbra, emanated? I mean, 1966, Miranda versus Arizona. An accused confession is presumed involuntary and inadmissible unless the accused is admonished immediately upon arrest that counsel before he's being questioned of the right to remain silent, and that counsel is going to be provided before questioning. That means if you don't advise him, we're going to presume under the Constitution that your confession is inadmissible. Where is that mentioned in the Constitution? 1967, Loving versus Virginia. State anti-miscegenation laws, I can never pronounce that word, violate the 14th Amendment's due process and equal protection clauses. In other words, the state cannot prohibit people of different races from getting married. And for good measure, in 1973, 4 years after Warren retires, Roe versus Wade, which held that the right to privacy protects a woman's decision whether or not to carry a pregnancy to term during the first trimester, and that's been overruled. Okay, and as to the government in general, between 1933 and 1968, conservatives had been out of power much more than in power. In fact, other than Eisenhower's 2 terms, Democrats had been at the White House the entire time, from 33 to 68. During those years, and even during the 1970s, Democrats had been in the majority party in one or both houses of Congress, with very few exceptions. From 1933 on, the size and reach of the federal government expanded exponentially. Just think about it. Conservative opposition was overridden in connection with federal oversight and supervision of both banking and securities markets, new programs such as Social Security, child welfare, unemployment insurance, desegregation of the military, and public education, laws establishing minimum wages, equal pay, labor's right to join unions, collective bargaining, and the right to strike, the nationalization of minimum standards of fairness in criminal cases, in religion, an emphasis on the First Amendment's establishment clause over the free exercise clause, and the 1964 Civil Rights Act and the Voting Rights Act to effectively end more than a half century of Jim Crow. For years, conservatives had complained that the liberal Supreme Court decisions expanded rights and federal power far beyond what the Constitution allowed and beyond what they saw as a traditional view of limited government. In their view, Supreme Court decisions judicially created new rights and went far beyond what they saw as a traditional view of limited government. They didn't follow the law. Instead, they didn't follow what they called strict construction. That was the buzzwords in the 1960s from the conservative side, strict construction. When running for president in 1968 and 1972, Nixon pledged to appoint only strict constructionists to the Supreme Court if he were elected. Ford did the same thing in 1976. Reagan did it again when he ran in 1980 and 1984. Bush Sr. ran in 1988 and 1992, again, pledging to appoint strict constructionists, and Bush Jr. in 2000 and 2004. And Trump simply turned the process of selection over to the Heritage Foundation, a right-wing think tank. Strict construction was a mantra of Republican political rhetoric during the 60s, 70s, 80s, and right up till now. In a sense, originalism as a doctrine is an alternative way of promoting strict construction, but with more sex appeal. Or it tied strict construction to the nation's founding. and thereby gives it more power. Conservatives argued that they were being true to our nation's past and in sync with the founding fathers. Relying on the text of their Constitution gave their conservatism both a gravitas and an argument that strict construction was not merely a conservative view, it's legitimized by being true to the nation's founding. Originalism implies criticism of being liberals for being untrue to the nation's founding project. If you're not an originalist, then you're not being true to the Constitution, and thus rendering their views less valid. Rehnquist and Scalia were the first avowed originalists on the Supreme Court. Alito and Thomas and Alito aligned with them very quickly. Now Roberts, Gorsuch, Kavanaugh, and Barrett all claim to be originalists. And the idea has become so powerful in the American imagination that Elena Kagan, during her confirmation process, said, "We're all originalists now." When dissenting from conservative decisions, so Justices Sotomayor, Kagan, and Jackson will challenge the historical assumptions of the majority, but not necessarily challenging the idea of originalism itself. That's how powerful it's become. At this point, are there any questions about what we're talking about when we talk about originalism? Okay, yes.
Yes, the question, were those theses applied to other things besides the Constitution, like laws and contracts and things?
Yeah, to some extent, the question is, were these four concepts that I talked about in this slide, were they applied to other ideas in law? And I would say yes, because originalists say that statutes should be read the same way. And that's really where it comes down to. Because what are our sources of law? Our sources of law are federal and state constitutions, federal, state, and local statutes. That's what the law, and opinions of courts, stare decisis, prior opinions that have case precedents. Those are the sources of law in American society. And all of them, they would argue that you could take these ideas of the fixation thesis, the meaning of what's written down should be based on the text. That the public meaning of it's important. It's how people understand it. That these words are not mere symbols. They're symbols. They do create law. They have meaning. And the last one is that you both interpret it and construct it. You interpret it to find out what it means. Construction means what is the effect of what it means. What's the legal impact? And yes, they would say those apply. Yes.
How do you go back in time and determine what the word meant by the public?
You're going to have to wait because that's going to be covered in the rest of my lecture.
All right.
Okay, let me go on. There's a very good example of what is an originalist decision. And that is District of Columbia versus Heller that was decided in 2008. Could I have the next slide, please? Heller established that under the Second Amendment, Americans had a right to bear arms that was not tied to or dependent upon being the militia membership or activity. And let me read it to you. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. A well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. That is the Second Amendment. Americans had a right to, so that's what the slide says. And the case was an ordinance in the District of Columbia that barred all individual ownership of handguns, and it said you can't keep a loaded rifle or a shotgun in the home. Justice Scalia wrote the majority opinion. He was joined by Roberts, Kennedy, Thomas, and Alito. Stevens, Breyer, Ginsburg, and Kagan dissented. Now, Heller was brought as a test case. That's one slide to me, thank you.
Okay.
Heller was brought as a test case designed to promote a specific decision. Jenna asked me earlier, what is a test case? This is an example of one. The case was planned by the Cato Institute. It was financed by the NRA. There were 6 plaintiffs, 6 named plaintiffs in the case, 4 whites, 2 blacks, 5 straights, 1 gay. Their ages range from mid-20s to their 60s. Several lived in high crime areas, and all of them expressed a need that they wanted to keep loaded guns in their homes for protection. So that was the case. How do test cases get brought? They get brought with an aim of testing or changing the law. They want the court to rule a certain way, and the case is set up so that it will present the issue in a way most favorable to the position of the people financing and bringing the case. That's what a test case is. Brown versus Board of Education was a test case. The NAACP pioneered the use of test cases. Actually, they didn't. Lochner versus New York, which was a case in 1907 to determine whether in New York's law that regulated hours for bakeries was a test case brought by people who were opposed to New York's law at the time. This is something that's been around for a long time. Why? Litigation's expensive. I used to say when I practiced law that I couldn't afford me, because it's very expensive. And when you're talking about getting guys from the top legal scholars and Supreme Court litigants, their hourly rates are not in hundreds of dollars an hour, it's in thousands of dollars an hour. Individuals can't afford this kind of stuff. When I practiced law, the biggest issue I had in the clients who wanted to file a lawsuit was, can you really afford this lawsuit? That's a major issue. Okay, that's the case. Scalia's majority opinion is long. It's 63 pages, but I'm going to break it down to 10 key points that illustrates how he applied originalist ideas to decide the case. 1, the Second Amendment should be interpreted as it was understood by ordinary voters when it was adopted in 1791. According to the notes of the Committee on Style of the original Constitution, the language to be used in the Constitution was written to be understood, deciphered by ordinary Americans. In other words, lay off the legalese. Second, the Second Amendment has 2 clauses, a prefatory clause and an operative clause. The first clause, under linguistic practices of the time and still today, a prefatory clause does not always limit the operative clause, only if it clearly states so. And that's generally true linguistically. A prefatory clause does not imply or automatically means it limits the operative clause, only if it says so. So in other words, if it says a regulated militia being necessary to the security of every state, the right of the people to keep and bear arms in a militia shall not be infringed. That's an expressly applying the prefatory clause to the operative clause. Scalia is saying that unless that kind of express intent is there, linguistic practices says that it doesn't. The operative clause declares the right of the people. He notes that there are 9 other references to the people in the Constitution and in the Bill of Rights, and all of them refer to the people in a general sense. None of them do so in reference to a specific entity, idea, or subset. Therefore, the words "the people" means everybody in the nation in the operative clause. This contrasts with the militia in the prefatory clause. In the late 18th and early 19th centuries, the militia was a subset of men in the community who joined in a body, elected officers, occasionally had training, and were obligated, if called upon, to provide armed defense. Therefore, the right defined in the operative clause is an individual right that belongs to all Americans. That's basically how he interprets the amendment. The words arms and keep and bear in late colonial and early American times, as reflected in the early edition of Noah Webster's dictionaries, were not terms of art. They simply meant to have weapons and were not understood to always be tied to military use or connection. The opinion notes that newspapers of the times referred to men being armed in both military and non-military contexts. In reviewing both English and colonial American history from when the Second Amendment was adopted, Americans understood that people needed arms for individual purposes, from putting food on the table to protecting one's home and families. This was normal, especially if you were out at the peripheral edges of society where indigenous peoples' raids were something you always had to worry about. Turning to the prefatory clause, the opinion notes that in 1791, every community had a local militia in which virtually all adult males were called upon to join if the need arose. Well regulated simply meant proper discipline and training. Because militias were important to every community and among the first thing tyrants tried to eliminate, the prefatory clause, Scalia says, was inserted to remind people that militias were important and shouldn't be ignored or disbanded. That's why he says it's there. The reference to militias did not imply that it limited the right to keep and bear arms. He also noted, and this is the 9th point, he looked at the early state constitutions that were in existence. He looked up until about 1825, and he noted 14 of them recognized an individual right to bear arms. Several of them referred to self-defense and other individual uses. None of them conditioned the right to bear arms on being in a militia. So all the state constitutions that existed by the 1820s protected the individual right to bear arms, and none of them tied it to the militia. The Freedmen's Bureau that was formed by Congress in 1866 to protect the rights of former slaves included among the rights to be protected was the individual right to own and carry arms, because under slavery, all African Americans were prohibited from owning or possessing or keeping or having a weapon in their possession. That was basically an offense for which an African American could be punished, and if he was a slave, punished very severely. The Freedmen's Bureau made it a point in its regulations that among the rights it was going to protect was the right of slaves former slaves to have and bear arms. And by the 1860s, there were no state militias. Why? Because there was because states had most of the states had adopted National Guard provisions by that time, and the National Army was a permanent entity. Before, when the Constitution was written, there was no idea of a permanent national army. The founders hated the idea of a permanent army. That was what Britain had. That was the redcoats. The militia, the state militias, would be called into national service, and then they would be part of the national army on a temporary basis. When the Civil War started, both the army was expanded and the state National Guard, the state guards, were called into service. That was what happened in the Civil War. So you had all these 10 reasons why the right to bear arms was not qualified by being in the militia, that it was a right to belong to all Americans. Now, the opinion notes the Second Amendment right to keep and bear arms, like any right, is subject to reasonable regulations that do not unduly interfere with the right being protected. For those of you who were around here in 2020, which is the first time I taught OLLI classes, and I did one in February of 2020, I taught a class on the Second Amendment. And at that time, I said that the scope of allowable regulation is as much a political issue as a legal one. Why? Because whether a regulation is reasonable and doesn't, quote, unduly interfere with the right being protected is itself a moving target. It's a political question. This term that's right now, the Supreme Court's just starting. The Supreme Court has already granted certiorari in 2 Second Amendment cases. The first one tests the legality of a Hawaiian law, a state law in Hawaii, that says that taking a concealed weapon onto private property is illegal unless you first get the permission of the property owner. The idea was that you can't carry a concealed weapon into a restaurant unless you get the prior consent of the restaurateur, the owner of the restaurant, to have the weapon in. And the question is whether this unduly interferes with the right to bear arms. The second question is whether a law that no concealed carry permit can be given to anybody who has been guilty of or of possession of an controlled substance or uses controlled substance. This was the law that Hunter Biden was nailed on. And the question is this law constitutional? Does someone having used marijuana 5 years ago bar that person from owning a weapon? And Maryland state law has a state law that bans assault rifles. There's a test case now working its way through the courts to determine if this is constitutional. It may hit the Supreme Court this year, or it may hit next year. We'll see. So that's how the Teller case used originalism to decide the case. Its proponents believe that the doctrine provides predictability, stability, and insulation from ideological and political conflicts. That's a loaded quote. Why did I write the quote? That's a tough sentence. Let me say it again. They believe that it provides stability, insulation from ideological and political conflicts, and predictability. The idea is that law should be predictable. It shouldn't come as a surprise. It should be, this follows this. It should be stable. It shouldn't be all while changing, and it should be free of ideological or political conflicts. They allege that it prevents judges from serving abstract and changing ideas of justice that are outside defined constitutional limits. Now, I'm going to have more about this to say after the break. They take the position that when the constitutions declare rights, the act of ratifying the Constitution or the act of ratifying an amendment in which the right is declared brings the right into legal existence. It's a right then that the government must respect and protect. What the right protects, its scope, is determined by the common understanding of the words used at the time it was ratified. This is why Justice Scalia carefully parsed the meaning of the words of the Second Amendment when it was adopted. And the Heller case cites other evidence from the time in the past to show that such meaning was consistent with the people's understanding of what the right entailed when it was adopted. Personally, I don't think Heller's bad law. I think that the use of the prefatory clause does not necessarily qualify the right to bear arms to being in an official military body. What I don't believe is that banning assault weapons, banning bump stocks, banning open carry laws, require registration, require gun safety training, having background checks, and regulating gun show sales, and requiring traceable ammunition. I don't believe any of those unreasonably interfere with the right of a person to have an arm. I mean, we all drive cars. We have a right to drive a car, but the state can require you to have a license to prove that you know how to use it and regulate the way you drive your car. Why can't the state regulate the way you carry a gun or have a gun? You have a right to have it, but the state has a right to reasonably regulate it. What's reasonable is, I think is a political issue. It's not a legal issue. And if you say it's a legal issue, then I think, and you start drawing lines, then I think this is where constitutional law has its problems. Because not all rights are as specific as the right to bear arms, and therein lies the rub. Take the idea of due process of law. It appears twice. It appears once in the Fifth Amendment and once in the 14th Amendment. And it says in the Fifth Amendment. Nor shall any person be deprived of life, liberty, or property without due process of law. That's the Fifth Amendment. Fourth Amendment, the 14th Amendment. Nor shall any state deprive any person of life, liberty, or property without due process of law. Neither the Fifth nor the 14th Amendment specify if due process only applies to the fairness of official proceedings, such as trials and other fact-finding activities, or if it applies to all governmental actions that control individual choices and actions. That's what's called substantive due process. There's procedural due process, which means, is this trial, is this official proceeding fair? Do you have a right to a lawyer? Can you bring witnesses in on your own behalf? Do you have a right to confront and cross-examine the witnesses against you? Are the rules basically fair? Or what does it mean to deprive someone of liberty without due process of law? What does liberty mean in the Constitution? I'm going to get to that after the break. So that's the difference between substantive and procedural due process. And the Constitution doesn't say anything about which one it is. Which one are we talking about? Are we talking about both of them, or are we limiting due process just to procedural? And secondly, equal protection. I would say that due process and equal protection only have meaning when applied to specific factual situations. Context is everything. Equal protection means that if the law classifies people or sorts them into different groups and then treats people differently based upon how they're sorted, there better be a really strong reason for doing so. There must be a compelling state interest that does not unduly interfere. It's not, so you can't do it based on race. That's the whole idea of equal protection based on race. Yes.
What ICE is doing currently, is picking people up off the street without any.
Repeat the question.
Okay, I will, but she hasn't finished the question, Mark.
Okay.
Violates which of those, substantive or
Okay, the
procedural?
question is, does ICE stopping people on the street without due process, without reasonable cause, based on just the way they look or the way they talk, does that violate due process or equal protection? I could make an argument either way that it violates both. It can violate both, but the Supreme Court has held that for ICE to stop someone, it's not the same thing as probable cause to believe a crime has been committed, but reasonable suspicion that that person might be undocumented. And that's the Supreme Court said that's a different test. They've made that ruling already on the emergency docket. Whether or not it holds permanently will be seen. But yes, they've already decided that.
And it doesn't violate a right?
So far, it doesn't.
But the Constitution also, I believe, says you need a warrant. So if they have a person in mind who's undocumented, they still need a warrant.
Okay, the question that Gunther asked is, do they need a warrant? I'm going to answer. The answer is no. You're misstating the law there. If they have reason, if you are on the street and there is an insufficient time to get a warrant before you detain the person, because the person's going to be gone by the time you go find a judge to get the warrant. Can you detain that person long enough to get the warrant? Can you detain someone long enough to get the warrant? And the answer is yes, but you don't need the warrant in that situation. That's what's called reasonable detention.
Thank you.
I got one more, then I want to get going. Roger.
Does this apply only to American citizens? I mean, can we shoot and kill, say Venezuelans based on suspicion? And is that legal?
Okay, the question is, does this apply only to Americans who we kill or shoot Venezuelans based on suspicion? I would. The way you've asked the question, Roger, is definitely a loaded question. And I will say this, that no, you can't shoot him just because you don't like the way he looks. Because shooting him implies that you're responding to a threat to your own safety. That's different. If you're talking about detention, that's a different issue.
What if you just say?
All right, I got one more and that's quick.
Thank you. Could you please read or just summarize how the liberal part of the court, what they wrote in terms of Heller?
I'm gonna, okay, what, the question is, what did the liberals say about Heller? The liberals said basically that that it's gone too far. They actually wrote that the prefatory clause implied a limit. That was the position that they had to take, that it implies a limit. They also wrote that that requiring that people didn't need handguns were too much used in crime, that it was just as tradition in American history with Western towns required people to leave their handguns with the sheriff, that you couldn't walk around armed, you had to leave your handgun with the sheriff, that rifles were sufficient for protection, and requiring you to have it loaded was reasonable. So they attacked it on two grounds. One, that you didn't need a handgun, that was reasonable, and that you didn't need to keep it loaded. They also attacked. So that's right, and I'm summarizing because their opinions were 60-odd pages long too. Okay.
Arthur, one quick question. With the originalists, they're so literal. Could you assume that the population at the time to bear arms meant that you could have a musket and a saber, not a cannon or?
Okay, the question is, because you're talking about what the people understood at that time the right entailed, would that right be limited to the technological state of what you were in possession of at that time? And that's a very good question. And I don't know you could or you couldn't. I could give you arguments on both sides, that if there's a right to bear arms, the word arms itself is not tied to what the arms, to the technology at the time, but merely the use of the item. And that's the way it would go. Let me continue. The problem with getting to due process and equal protection is that they only have meaning when applied to a specific situation. Context is everything. Equal protection means that if you're going to treat people differently, you better have a damn good reason for doing so. Due process, whether it's procedural or substantive, essentially comes down to fairness. And the Constitution itself, the Bill of Rights, the 14th Amendment, do not provide you any guidance at all. Now, the 9th Amendment, which says it doesn't really help, it states that designating rights in the Constitution, quote, shall not be construed to deny or disparage others retained by the people, close quote. There's a line of cases going back quite a long time that held that this amendment means that the delegated powers of the national government are not expanded because it's not included in the Constitution or in the first 8 amendments. So when a case challenges an official action as either violating due process or equal protection, judges have to look at the context and decide if in a context a violation occurs. That's what equal protection means. That's what due process means. In what context does this apply? Originalists maintain that because the language provides no guidance, the context should be limited to those instances where the right being protected is, quote, give me the next slide, deeply rooted in the nation's history and tradition. This is the deeply rooted thesis. The language is taken from Justice Alito's Dobbs opinion and several others. And it says that where there's no words in the Constitution, when there's no words in the Constitution or its amendments to provide guidance, the context in which due process and equal protection apply, giving rise to a constitutionally protected right, should be limited to those rights that are deeply rooted in American history and tradition. That's the idea and the idea is to prevent judges from just making shit up, pardon my language. Otherwise, judges are making law by deciding in what context deserve constitutional protection based on their personal views. That's what the deeply rooted test is designed to prevent. But the concept deeply rooted is seriously problematical if you look at much of our history. African-American slavery and related racism is more deeply rooted in American history and tradition than any idea of racial equality or justice. American law tolerated slavery and then Jim Crow from the founding until the middle of the 20th century, except for a decade or so of Reconstruction following the Civil War. Almost as equally deeply rooted is unequal treatment of women. Attested coverture subsumed women's identities, legal identities into their male relatives and husbands until the late 19th century. Women lacked the right to vote for the first 130 years of our history. And legally vesting control over women's bodies to male-dominated state and local governments and medical associations continues. As to religion, the Establishment Clause was largely ignored until the 1940s through the 1970s. Evangelical Christianity has been deeply embedded in American culture through the First and Second Great Awakenings in the 19th century and the 18th century, the revival meetings in Chautauqua tents, declarations of Christian values at the onset of official governmental observances, from daily prayers at congressional sessions to local meetings of town councils from 1890 to the present. For much of our history, states legislated prohibitions of all sorts of sexual situations, birth control, abortion, so-called abnormal sexual practices, adultery, marriage infidelity, and homosexual relations. This is what's deeply rooted in American history. So when one suggests that the traditions of how Americans treated people over much of our history should control what rights have constitutional protection, lots of rights would not make the cut. Desegregated schools, public accommodations, voting, using contraception, both interracial and same-sex marriage, are not to be involuntarily singled out if one doesn't share the same mainstream religious views that are celebrated or in officially sanctioned religious activities. Progressive legal scholars claim that the deeply rooted test is weighted against historically unprotected groups, non-whites, women, the poor, those who are usually unprotected. This test itself implies that any holding to the contrary is judicial activism.
Yeah.
Wow.
I'm sorry?
Say that one.
The test itself implies that any holding to the contrary, any holding that gives constitutional right to something that is not deeply rooted in American history tradition is judicial activism, the idea of judge-made law. Progressives believe that originalism is deeply flawed, that it's a modern construct to support conservative, sometimes reactionary views. That originalist understanding of our history is itself flawed and misleading. And that's what I'm going to talk about after the break. Let's take 10 minutes. I got more. Say November 11th, the London Nelson Center will be closed. We'll resume here for the last class 2 weeks from today. It's going to be on climate change, the EPA, and government powers. And it's going to be the exact opposite of this lecture, because I feel this lecture, I know a lot about it. And next week, I'm going to be talking about stuff I don't know anything about. I was not an environmental historian, but it's an important issue, and I think I'm going to try and cover it. Okay. Where were we? I'm going to start with some basic American history. Originalism says that constitutional issues should be resolved based on how the words in the Constitution were originally understood when the Constitution was ratified or the Bill of Rights and other amendments were adopted. So let's consider some of the basic words or concepts. And I'm going to use three. I could do more, but I have limited amount of time. And the three words I want us to talk about are liberty, commerce, liberty, which is used in the due process and equal protection, shall not deprive any person of liberty without due process of law. So what does liberty mean? Secondly, commerce. Federal government in Article 1, Section 8 is given the power to regulate commerce among the several states. Just what is included in commerce? What does that power entail? And the nature of federalism itself. How people, when the Constitution was adopted, understood the relationship between the federal government and the states. So that's going to be the next section on the historical examination. So let's start with the word liberty. The 14th and 5th, the 5th and 14th Amendments say, and I'll repeat them again, no person shall be deprived of life, liberty, or property without due process of law. In the late 19th to 18th century, Americans thought that legitimate government was based on the idea of the social contract among the government and the people, between the governed and their government. Free people, liberty, lived in a country where the government embodied and respected the social contract. A person had liberty when the person's interest was represented by an elected representative, when a person had a vote, a voice, electing those who made the rules in which they lived. Liberty was synonymous with freedom and totally antithetical from being enslaved. And Americans at the time knew everything. They knew all about slavery. Race-based slavery was legal in virtually every colony north and south alike when the Constitution was adopted, when these words were adopted. Liberty meant not being under another's whim or control with nothing to say about it. Thus, the revolutionary rhetoric of the 1770s with Parliament and the British government, in which Americans were entirely unrepresented by Parliament and had no say, that the Britons were treating America like slaves, which gave us the right to rebel. That was the rhetoric of that, and so that's what liberty means. Liberty today differs. We think of it in terms, we take representative government for granted. And liberty in the context is freedom to and freedom from. Thus, how liberty was commonly understood in the late 18th century doesn't provide any guidance in resolving a current dispute over its constitutional meaning in the 5th and the 14th Amendment. That's what's wrong with the idea of originalism when you're talking about what is implied by liberty. Because if you're looking back to what liberty meant in the late 18th century, it meant something completely different than it does today. What about commerce? Article 1, Section 8 gives Congress the power to, quote, regulate commerce among the several states. To say there was a common understanding of what those words meant in 1789 assumes that such understanding was singular. But our history is much too messy. In 1789, Americans were deeply divided on what those words meant in the context of the national government's power to set economic policy under the Commerce Clause. Alexander Hamilton, his view was expansive. He imagined a strong national government, a powerful national government that fostered a thriving manufacturing center and a national financial sector kept in line by a government-chartered national bank. According to Hamilton, Congress's power under the Commerce Clause included chartering a national bank, promoting and financing the expansion of manufacturing. Jefferson disagreed. He dreamt of a nation of independent farmers. Jefferson repeatedly in his notes on the state of Virginia and in his correspondence written when he was president said, quote, "Those who labor in the earth are the chosen people of God." Agriculture was not commerce. In the context of Article 1, Section 8, commerce meant buying and selling in the carrying trade, transportation. That was it. He favored a weaker national government that left economic and social policies up to the states. Banking and manufacturing were state issues, neither created, financed, or regulated by the national government. Jefferson opposed federally funding canals and roads because doing so was not among the enumerated powers in the Constitution. And it didn't constitute commerce. Andrew Jackson, who was president from 1829 to 1837, had a similar view. He vetoed bills funding a national road, and he vetoed a recharter of the Second Bank of the United States because they were, in his view, unconstitutional. Madison went both ways. Madison initially opposed Hamilton's first Bank of the United States, but during his second term in the White House, the nation's financial affairs were so fouled up, the economy was so in the tank, that's a technical term, that in 1819, he agreed to Congress to let Congress create a second Bank of the United States. So he's on both sides. If Jefferson's view is correct, the federal government should never have been permitted to authorize construction of the Transcontinental Railroad and support it or finance it by massive donations of federal land to privately owned corporations. If Jefferson's view was correct, the federal government should never have been permitted to design, finance, and build the national highway system in the 1950s. Nor did Congress have the power to prohibit discrimination in any business enterprise by offering service to the general public, which it did in the 1964 Civil Rights Act, which the Supreme Court held was perfectly proper under the Commerce Clause in Heart of Atlanta Motel versus United States and Katzenbach versus McClung, both decided in 1964. So when 5 justices of the Supreme Court in 2012 held that the Commerce Clause doesn't allow the federal government to regulate the businesses of healthcare and health insurance, which 5 justices said in National Federation of Independent Businesses versus Sebelius, to being consistent with a common understanding of what commerce meant in the 1870s, they were not expressing originalism, but were expressing their ideological preferences as opposed to being consistent with the common understanding of what commerce meant in the 1790s. The ACA survived because Chief Justice Roberts joined the 4 liberals then on the court, Stevens, Breyer, Kagan, and Sotomayor, to uphold the ACA based on Congress's power to tax. So that's why the ACA survived. But 5 justices went on record, Roberts and the other 4, that health insurance and the business of healthcare and health insurance was not regulated by Congress under the Commerce Clause. So that's what I have. That's why it doesn't work in terms of commerce. Now let's consider the interrelationships between the people, the states, and the national government. Originalism presumes that there was a common understanding of what the respective powers of the national government vis-a-vis the states were when it was ratified. But that was not the case. There were competing understandings of the nature of the federal system between the people, the states, and the national government that no version of originalism can reconcile. I mean, I've pointed out just the difference between Hamilton's and Jefferson's views. Such disputes over the nature and scope of federalism is a staple of our history. In 1798, in response to Congress in passing the Alien and Sedition Acts during the last 2 years of the Adams administration, Jefferson and Madison, respectively, ghost wrote resolutions for Kentucky and Virginia. They're called the Kentucky and Virginia Resolves. Each contended that states had a right to individually decide if national legislation or action were unconstitutional. And if they said it was, they could prevent it being enforced within their state's boundaries. That was what they said in the Kentucky and Virginia resolves. In the Kentucky resolves that Jefferson co-wrote, he went so far as to say that a state could withdraw from the Union because the Constitution was nothing more than an at-will compact among the several states, which any state as a sovereign entity had the right of withdrawal. The New England states, they objected to the War of 1812 because it tanked their mercantile economy. I mean, Britain very, very successfully closed down the American coastal trade. In 1814, the four New England states, Massachusetts, Connecticut, Rhode Island, and New Hampshire, and I think Vermont too, sent delegates to a meeting in Hartford, Connecticut. And those delegates adopted the Hartford Resolutions, which included the intention to succeed if the war persisted. Now, the convention met in November of 1814. Unfortunately, it didn't. The peace treaty was signed that December in Ghent. And finally, we found out about it 2.5 months later when a ship finally came letting us know. By the way, the war was over last December. Forget about the Battle of New Orleans that took place in February because nobody knew about it. The nullification dispute in 1832 and 1833 over tariffs. John Calhoun led this, it was led by John Calhoun, who was vice president, by the way. South Carolina's legislature passed a nullification bill providing that the tariffs that Congress put in effect could not be collected in their state's port. And Charleston was the leading port in the southern colonies. They objected to it because it put a high tariff on all imported goods, basically which they needed to provide cotton to their slaves because it was cheaper to buy British cotton than American cotton because of the Industrial Revolution. And after some saber rattling on both sides, South Carolina withdrew the bill and Congress reduced the tariffs. So nothing happened. But finally, sectional differences over federalism and slavery led to the Civil War. I mean, there was a war. We fought a civil war based on the idea that a state could not keep slavery and say it had a right to withdraw from the Union in order to do so. More recently, disputes over the nature of federalism were at the heart of the Southern Manifesto. How many of you remember that? It was 1960, it was written in the early 1960s or late 50s, in which the Southern states claimed a right to resist the Supreme Court's Brown versus Board of Education and school desegregation. So I've gone through this exercise to illustrate how unfixed the Constitution was when it was created. Not just the specific provisions such as regulating commerce, but even in its essential nature. Originalism assumes a singularity of meaning, an understanding of what the concepts, the words in the Constitution entailed. But there was no singular common understanding of those terms. And it's neither the founders themselves, nor the people, nor the delegates to the various ratification conventions. If none of them agreed on what it created or how it could be interpreted, how can you have originalism? By assuming singularity of meaning and continuity between the constitutional past and the present, originalism is every bit as imprecise as what the originalists complain about. That's where I come down on it. Originalism selects a view of history that says we have drifted from our foundations and need to find our way back. But neither the founders nor the people in the late 18th century had a unified understanding of what the terms meant. And few of them saw their work as something that should be adhered to no matter how much things might change. Jefferson, in a letter to Madison in September 1789, which the onset of the French Revolution, he wrote the letter in September. This is 3 months after, or 2.5 months after he wrote it. It was September, I think, 28th or 29th, and the Bastille was June 14th, July 14th. Jefferson wrote, "No society can make a perpetual constitution. The earth always belongs to the living generation." And he said somewhat tongue in cheek that all laws should be reconsidered after 19 years. So is originalism a hoped for return to an idealized conception of our nation's origins? Originalism and its opposite has been called living constitutionalism. That's the opposite of originalism. Are competing answers to a modernist dilemma. We have an old constitution and society, but society has fundamentally changed.
Yep.
That was then, this is now. That's really the problem. Originalism says the text is then understood controls. A living constitutionalist says the text may indicate, but it doesn't necessarily control. The Constitution is and should be shaped by evolving practice and circumstance. Our conflicted history and the Constitution's language are resources, but not commands. Originalism sees history as objective, but history is very subjective. I'll give you 3 examples. First, what other people back in the past thought was important to say involves subjective decision. You want an example of that? Look at the questions that were asked at each of the censuses that are taken every 10 years. Those questions, every 10 years, they're asking different questions. And those questions reflect the political issues and what people thought was really important to know at that time. So some of it was, where were you born? Are you enslaved? What's your race? How many kids do you have? Do you own your property? All these kind of different questions were asked at different times, and they tell us something about the subjectivity of what people thought about when they were thinking of this. That's one level of subjectivity. Another level of subjectivity in history is what I call serendipity. What managed to survive? Buildings burn, paper disintegrates, letters are lost. This has a big difference. There's a lot of luck involved in what we know about the past. And the third level of subjectivity is the cultural assumptions and prejudice that people today bring to the table when considering evidence of the past. We have our own ideas. We have our own environment training. I'm sure that Justice Scalia and I look at history differently. So that's another level of subjectivity. Justice Barrett has said that history is a tool. I'm saying history is not a tool because it's a tool, it's flawed. It's like the expression I came in. It's like using a screwdriver that has all the stiffness of a wet noodle. Just doesn't work. You know, it's also been said that history is written by the winners. When you consider the past, what's generally understood by the meaning of words in the past, keep in mind that mostly the voices of white men or property were the voices that counted. As Madiba Denny states, she in a recent book, The Originalist Trap, right here. It's very polemic, but it's pretty good. You'll find yourself nodding a lot as you read it. She argues that originalism mobilizes, that it privileges the historic voices of the already powerful, when it's the marginalized voices which most need to be heard. She argues that originalism mobilizes conservatives to achieve their policy goals. It's the doctrine of choice for political conservatives who oppose progressive changes that reduce their ability to shape society. It's a wishful return to an ideological conception of an imagined national origin. That's her thesis.
Can I
Now,
ask a question?
I'm not sure I buy that.
Oh.
It's a little cynical. Calling originalism frozen freedoms and saying that originalists favor a dead constitution to maintain power is pejorative name calling. It's right there on a par with the idea of a judicial activist or judge-made law. By education and experience, I believe there's a value of tradition. And a book that I remember reading when I was in college And I remember this very clearly. And as a lawyer, you have to be a little bit of a traditionalist. This is Chesterton, who wrote it. For those of you who watch PBS, Father Brown,
Yeah.
Chesterton wrote all the Father Brown mysteries. G.K. Chesterton. He wrote, tradition may be defined as an extension of the franchise. Tradition means giving votes to the most obscure of all classes, our ancestors. It is the democracy of the dead. Tradition refuses to submit to the small and arrogant oligarchy of those who merely happen to be walking about. All Democrats object to men being disqualified by the accident of birth. Tradition objects to their being disqualified by the accident of death. Democracy tells us not to neglect a good man's opinion, even if he is our gardener. Tradition asks us not to neglect a good man's opinion, even if he's our great-grandfather. I buy some of that. By tradition, education, experience, I think there's a value in this. But I also believe that what is or isn't constitutional changes over time. The post-World War II civil rights movement, the second Reconstruction, is comparatively recent. And let's face it, at our ages, events in the 1960s are current events. I mean, people ask why I didn't teach, current U.S. history. I said, because I'm not objective. It's too much current event. Modern civil rights, the feminist movement, and both interracial and same-sex marriage could not have been around long enough to be considered deeply rooted in American history and tradition. But they should be. They should be considered when it comes to the context in which due process and equal protection protect individual rights. Harvard's Charles Reich, R-E-I-C-H, a leading progressive legal scholar, said, quote, stagnating jurisprudence in the face of social change causes constitutional atrophy. In constitutions, constancy requires change. That when you take vague concepts like equal protection and due process that are context dependent, to continue to apply them requires you to understand that context changes and that social values need to be respected. Originalists argue that living constitutionalism promotes unrestrained, undemocratic judicial lawmaking, for which originalism is the antidote. That originalism is the only alternative that's based on objective standards. And I think that the idea of judicial activism is a problem that, yes, we need to be aware of. Yes.
So there's a Zoom question. Can I ask it now?
Yes.
Okay. If the Constitution is imprecise, how can one know if you take an oath to adhere to the Constitution?
Well, that assumes that is that the question that for the people in the room, because everybody on Zoom should have heard what Mark said and should have seen the question is, how can you take an oath to defend the Constitution if the Constitution is imprecise? Well, the answer is, of course, you take an oath to defend the Constitution. You defend, but the Constitution you defend is an imprecise thing. So what you're defending is something that's constantly a work in progress. That's how I would answer that. Okay. Originalists say that they have the only alternative to what's based on objective standards. That's based on objective standards. There is a problem with judge-made law. We live in a democracy. Federal judges is the least democratic responsive branch of government. They're not elected. They serve for life. I mean, you look at the judges that Trump has appointed. God, I don't want those people deciding my stuff, deciding how I live, and any more than someone who might disagree with me wants judges appointed by Bill Clinton or Barack Obama to decide how he's going to live. So yeah, this is a problem that judges should not make law, that there is an issue. But it's an issue from both sides, because originalism is judicial activism by another name. It's every bit as imprecise as what they're complaining about. When a federal judge or a Supreme Court justice cherry picks examples from the past, chooses whose voices mattered in the past, and reads history selectively and calls it being objective, he or she is being subjective. And it's subjectivity at its worst because it's dishonest. To its critics, originalism is not a theory of judging. It's a rhetorical quote. Here's Miss Denny again. It's, quote, a rhetorical ploy to make it appear that decisions are based on something other than political ideology. You should know better. The drugs are at the airport.
Your husband.
He's right here. You should check who's going. The idea of a living constitution is not new. Chief Justice John Marshall, who served from 1801 to 1836, wrote in one of his cases, and I didn't write down which one it was. We must never forget that it is a constitution we are expounding, a constitution intended to endure for ages to come, and consequently to be adapted to the various crises of human affairs. In a treatise that he called The Common Law, written in 1881, Oliver Wendell Holmes wrote, and by the way, I remember this because it was on the wall at my law school. The life of the law has not been logic, it has been experience. The felt necessities of time, the prevalent moral and political theories, intentions, and public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have shaped the rules by which men should be governed. And Justice Robert Jackson in 1952, Jackson was a Roosevelt appointee to the Supreme Court. He was the lead prosecutor in the Nuremberg trials, wrote, quote, just what our forefathers did envision or would have envisioned had they foreseen modern conditions must be divined from materials as enigmatic as the dreams Joseph was called upon to interpret for Pharaoh. Marshall, Holmes, and Jackson each acknowledged that deciding questions of constitutional law may require considering values and circumstances that have few roots that existed when the Constitution or its amendments were adopted. So they're saying that to interpret the Constitution, it requires us to consider values and circumstances that really that are not deeply rooted in American culture and tradition. You cannot be tied to the past. As Jefferson said, life belongs to the living. The idea of a living constitution is not carte blanche to rewrite our constitution or to ignore our history and traditions. Originalism is right in that regard. You can't just ignore the past. It's there. And tradition is important. Judicial restraint is not always bad, and usually it makes a lot of sense. Judges need to be aware that in a democracy, the people's political choices merit respect. And for us today, I'm in the minority among a lot of Americans, but I'm a small Democrat. I'm a Democrat with a small d. I believe in the people's right to do it. I don't say because of my education, because of my experience, that I'm more able than quote, the people to say how we should live. I'm a Democrat with a small d. And so the people's political choices do merit respect. But originalism is neither original nor historical. And it's not democratic. It's a construct that denies that our Constitution and common law is a living, organic edifice. It binds our Constitution to a fixed but inaccurate image of the past. It ignores what might be learned from our collective experiences. Even more, it ignores what our grandchildren will learn. We might need rights that could not have been dreamed about 250 years ago, or need our government to do things not then imagined. William Lloyd Garrison, one of the premier abolitionists in the decades before the Civil War, called the Constitution a compact of death because it explicitly justified, it allowed slavery to be legal. And he said people should not, don't vote. The Constitution, the Constitution shouldn't be ignored. It's a document, it's a compact of death because it sanctions slavery. And because it sanctions slavery, it's all wet. Frederick Douglass, who was an escaped slave, disagreed. He said the Constitution was, quote, a beacon of liberty, not for what it said, but for the ideas and ideals of justice and freedom that it represented. I'm with Douglas. And that's what I have to say about originalism. Questions?
When you compare the British non-British constitutions and how that functions without written down words.
Repeat the question.
The question was, how does our constitutional system compare with the Britain's unwritten constitution, which doesn't have written down words? And the answer to your question is the Parliament is supreme. The king rules in Parliament. But Parliament, because of tradition, Britain's class distinctions, Parliament is really, when you come right down to it, is essentially fairly conservative in the sense of resistance to wholesale change. When you think about it, the opportunities of wholesale change in Britain have really been very few. There was the Attlee government that came in after World War II that began nationalizing. The famous Winston Churchill saw Clement Attlee in the bathroom next to him and said, and said, Attlee complained to Churchill that you're being very standoffish, Winston. And Winston says, every time you see something, you want to nationalize it. But basically, Britain Parliament survives because of its essential conservatism within the class system. America doesn't have that class system. It doesn't have the idea of classes which balance each other, preserve balance, and therefore prevent going off the deep end. We put separation of powers to replace the class distinction with separation of powers.
So
Yes.
to add on that, it's a system of common laws and precedent in England. So wouldn't that be the ultimate thing that would be more flexible and changeable?
The question is, would common law be the ultimate thing that's more precedent and less changeable? Yes and no. Precedent is equally important because we operate on a common law system with a written constitution. We're operating under the same idea of an adversary system that determines truth through the judicial process, and judicial opinions by appellate courts are worthy of respect and should be followed unless they are clearly erroneous. Unless, they just totally screwed up, they don't make mistakes. Plessy versus Ferguson might have been what people wanted and understandable in 1898, which allowed separate but equal, but in 1954, in terms of public education, it violated equal protection. Dobbs, clearly erroneous, etc. Yes, sir, Don.
How does the unified executive theory work with originalism?
How does the unified executive theory work with originalism? The idea is that the Constitution says that the executive power is vested in a president of the United States. So they are claiming that they're being coherent with the Constitution. The Constitution in Article 2 is very clear. It says the executive power shall be vested in the President of the United States of America. Vesting. What does the word vested means? Vested means endowing someone with authority at law. With a president, not a panel of presidents. So the idea that the Constitution made a choice of putting the executive power under the control of the president is consistent. The unitary executive is consistent with originalism. Yes, Roger.
You mentioned and quoted several people talking about the living Constitution, but all of them came after the Constitution. was there, when the Constitution was written, or during the Federalist Papers, say, was there a thought of this? Did those, people think that the Constitution would have to change, or interpretations of it would have to change in the future?
Okay, the question that Roger asked for the people on Zoom is when before the Constitution was ratified, were there disputes or was there thoughts about how it would need to be interpreted if it was being adopted? And the answer to that question is yes and no. It depends. And but now I get to explain it. First off, Roger mentioned the Federalist Papers. Federalist Papers were written by five of them were written by John Jay, who was an avowed nationalist. 30 of them were written, there were 85 or 87 of them. About 32 of them were written by Madison, who was essentially a Federalist, but not entirely, because he was Jefferson's protege. But when he was writing in the Federalist Papers, he was writing to get the Constitution adopted. He was telling people that don't be worried about this, you're going to be okay. And Hamilton was an avowed nationalist all the way around. And the purpose of the Federalist Papers was to get the Constitution ratified in New York. So it is basically the thoughts of the winners. Because that's what it was. There were anti-federalists who had different views. And many of them opposed the Constitution because they felt it vested too much power in the institutions of the national government. And that it was a threat to people's liberty because of the amount of power that it gave the national government. And that's what the Federalists had to overcome in the ratification debates. I'm not aware of, and I've read a fair amount of the Federalist Papers. I've read probably 3/4 of them, and I've read about maybe 20% of the anti-federalist views in several books on the subject. And most of them don't talk about were people arguing then about how are we going to interpret this thing if we ratify it? They were considered, if we ratify it, is the government going to have too much power? They were asking a different question. Yes.
Why did they make the amendment procedure so difficult?
The question was, when did they make the amendment procedure so difficult? Or why did they make it so difficult? The amendment procedure is in Article 5, and it gives two ways of amending it. One is 2/3 of both houses shall deem it necessary, can propose an amendment to the Constitution or to the appreciation of 2/3 of the several states. So that if 2/3 of the House can propose an amendment, and if it's ratified by 3/4 of the states, it's valid. Or if 2/3 of the states call for a convention, we'll hold a convention. That was the amendments procedure. The question is, why was it so difficult? First off, at the time it was adopted, it wasn't being perceived as being too difficult. A lot of states had provisions that were much more difficult. Kentucky, I'll give you an example. Their initial constitution required, first off, that it be approved by 2/3 of the people voting on the issue, not 2/3 of the people who voted in the election, but 2/3 of the people voting on that issue in 2 consecutive elections. That was the rule in Kentucky. A lot of people's states said it should be very difficult because this is not the same as the statutory law. This is a higher law. It should take a lot more political will and political power to amend the Constitution than it does to change a statute. Because constitutions are more important. They are a higher law than statutory law. And as a result, that's why state constitutions constitutionalize issues that have nothing to do with the power of government and have everything to do with individual, private, personal, and economic relationships. California's constitution is a case in point. A lot of them have it. I know, I wrote my dissertation on this subject. Yes, sir.
I guess I appreciate what you're saying, but I think another question about the reality. It seems to me when you read the dissents of Jackson, she's talking about the reality of how this is gonna affect people in 2025. When you listen to Thomas, on the other hand, it's like he lives somewhere else. He's just writing this, and does he realize the reality of how it's gonna affect the population?
Okay, so the question is, and I'm gonna reduce your question to the topic of original. Do originalists, when they say that we should apply originalisms to what the Constitution meant then, or deeply rooted to, are they concerned with how it's applied now? Or how it's gonna impact people? And they will tell you no, that that's not our system of government. Our system of government is based upon this Constitution. And if it's gonna impact people wrongly, they have a remedy, which is to amend the Constitution.
Pass a law.
Or pass a law.
Well, are they hiding behind that because they know how onerous it is?
Are they hiding behind it? Now you're saying that they're intentionally being disingenuous.
Yes, sir.
And I'm not gonna say that any of them are being intentionally disingenuous because I'm not there. They might firmly believe that. A man who is crazy and thinks it's a chicken, you're never gonna convince him that not it's a chicken. If you don't believe it's a chicken. I don't know what else to say. Yeah,
I really struck in your comments about how messy this is and how subjective it is. And, I would say I'm more compelled by the living constitutionalism.
probably everybody in this room is.
But even so, I think that there is a risk of willy-nilly.
Yes, there is.
And so my question to you is, what do you think is a legitimate underlying authority that could help guide judges in making decisions that, are the guardrails there to help?
I would want to know what the context is that you're talking about, because it all comes out to what is that context? And do I think that given our history and tradition, and given the needs of today, where are the balances? Does it need to be, is it something that should be constitutionally protected, or is this something that should be left to the political processes? If different states have different ideas, is that okay? If the different states choose to treat people differently, is that okay? Based upon that issue. If the answer is no, then it's deserving of constitutional protection. But I'm gonna say, I can't answer that other than in terms of context.
Do you think the Heritage Foundation would be the guiding principle? Yeah, of the originalists?
Well, and so far it has been. Is the Heritage Foundation the guiding principle and the guardians of originalism? I would say probably, yeah, they agree with it. And the heritage implies originalism. That's, this came out of, originalism came out of conservative academia, which is what the Heritage Foundation is. It's a think tank. And most of conservative law professors are card-carrying members of Cato Society, the Heritage Foundation, or what have you. Just as liberal law professors are card-carrying members of the ACLU. Yes, sir, Gunther.
Yeah. My takeaway is, I think the very important question in front of the Supreme Court is the tariff issue. And I think they're starting to discuss that. And
Yeah, they're gonna argue, it's gonna be argued about tomorrow.
yeah, exactly. And when I listen to you and look at regulating, there's nothing in the Constitution about tariffs.
Yes,
or
there is.
taxes. Oh,
Yes, there is.
but you talk about.
Article 1, Section 8. It says at the very beginning. Article 1, Section 8. Congress shall have the power to lay and collect taxes, duties, imposts, and excises.
Yeah, it's Congress, but we have a president who's.
To pay debts and okay, it says Congress shall have the power to do.
He is ignoring.
All right, there's a statute that Congress passed in Carter's president. And I talked about this last week. The first class, the IAAC or whatever it is. That says that in a state of national emergency, the president shall have certain powers on an as-needed basis. And one of them implies to make decisions regarding what may be imports and exports. And the idea behind that was it would give the president power to say, no, we're not going to allow you to export this type of information technology to our enemy. And we're not going to let you import this type of stuff because it's detrimental, based on a presidential finding. Does that power include the power to tariffs? Now, when the Supreme Court set the matter for argument, in one of the in one of the two cases where they framed the issue, they noted that the power to tariffs had never been used in the context of this act before. In today's LA Times, Erwin Chemerinsky, who's the dean of my law school, has an article on this. And his question is if they're going to follow the law, which seems pretty clear that Congress should do it, or are they just going to rubber stamp Trump because they're a bunch of rubber stamps?
Trump was right.
The problem is that they've already collected $1 trillion worth of the tariffs. And if they're illegal, does that mean they have to give it back? So I don't know what they're going to do. Yes, they should follow the law and they should be illegal. Are they going to require them to give it back? Probably not. They're going to cut the baby. And they're going to tell Congress, you figure it out.
What is the wording of the way that the question is posed to them about tariffs? Because this, there are cases where.
Okay, there's two. The question is, how was the question posed by the Supreme Court when they granted certiorari? What were the legal issues that the Supreme Court identified? They had issued two. One was imposing tariffs contemplated by the terms of this act. Secondly, even if it was contemplated by the terms of this act, did it violate the major question doctrine and therefore be an unconstitutional delegation of power from Congress to the president? That's the two questions that they posed on the tariff issues. First, was it within its power under the act, yes or no? If yes, is the act itself, if it allows this, unconstitutional because it violates separation of power? That's the way they define the issue. Okay, no more on that one. We could talk about that all day long. Any other questions?
Yes,
Okay, it's,
I have a question.
25 after. I've been going for 2 hours, my folks. Oh, I got one more on Zoom. What is it?
Wait, I don't see it.
If you don't see it, it's 10, 5, 4, 3.
I
have one.
If one takes an oath to defend the Constitution, it seems that the only time the military can act against a foreign power and never from within. The only way that the military can act is not against a foreign power, not within.
Okay, then the question is, and you're really, the question is, can, if you're taking oath to defend the Constitution, what does it mean about sending the military into the cities, using the military domestically?
Right.
The Constitution says very little about it, except that it does give the executive broad powers in the event of insurrection. And what constitutes an insurrection or an emergency? And it's a moving target. So that's the answer. The person who framed that question is framing it from a point of view. And be careful when you ask questions from the point of view, because you're assuming what the answer should be by the way you ask the question. That's for an originalist. Originalists do this all the time. And I'm saying it's every bit as wrong for liberals to do it, and it's every bit as misleading for liberals to do it as it is for conservatives to do it.
It's a question of what's an emergency.
It's a question of what's an emergency. Okay.
Okay.
Thank you.